For today's cover, we cover a prisoner who complained about discipline and then was disciplined even harder in retaliation for the complaint. Hello, my friends. Welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earn your subscription. For today's coverage, we're covering the case of Lawrence Higgins versus Ernst Navarrete and others. Lawrence over here is in prison, and he was found to have marijuana in his system. This caused a classification change within the prison as to what kind of prisoner he was, what kind of privileges and supervision he had. He filed a complaint, which caused that to be overturned and reconsidered. And then what happened on reconsideration leads us to this case, because it appears very directly that he was retaliated against for his complaint. So we're going to read this. Let's get started with this. In February of 2013, Ernst Navarrete, then an officer of Texas Department of Criminal Justice, ordered Lawrence Higgins, Texas inmate, to provide a urine sample. The sample tested positive for marijuana. Prison officials held a disciplinary hearing and found Higgins guilty of using marijuana and changed his custody categorization from G2, general population, to G4, medium custody, the latter of which involves less out-of-cell time and more restrictions on recreation and inmate job opportunities. Higgins filed a grievance regarding the custody characterization, and prison officials overturned the previous decision because Navarrete had not signed the required documentation. So yeah, he was elevated in category, and he complains and says, "Wait a second, this is improper." So the warden overturns it on the basis it wasn't signed and returns it back for further analysis. So in May 2013, at the rehearing, Higgins was found guilty of using marijuana at the prison and was then brought before a custody classification committee for the second time. But by this time, because of a promotion, Navarrete was the head of the committee. Custody classification is determined by a majority vote of 3 members. Here, Navarrete, Deleta, Jones, and Betty Germany. Navarrete asked Germany what they usually do in these cases, which, you think he would know because he's now the head of the committee, but whatever. And she replied, G4 medium custody. Then Navarrete asked Jones what her vote was, to which she replied, G4 medium custody. Navarrete then stated, quote, "I remember this case now. This is the one where you filed a grievance, and the case was overturned because I forgot to sign the paperwork." Recognizing the 2 G4 votes, he then said, "I guess we're going to leave you as you originally put for this case on G4 medium custody, but let the record show that I would have rather put you in G5, closed custody for all this trouble." Then Jones said, "Oh, wait a minute, I want to change my vote to G5 closed custody." Higgins was assigned to G5 custody. So yeah, he complained about the system not working, and on remand, they said pretty specifically they were doing it because of the hassle of the thing from the problem. So he's being retaliated against for his conduct, his First Amendment conduct. So we have to get into that. Higgins filed an unsuccessful grievance, and then in August of 2013, Higgins filed a complaint against Navarrete, Jones, and the warden, pursuant to 1983. He alleged that Morris improperly ordered a rehearing of his case and that Navarrete and Jones retaliated against him for his use of the grievance process by increasing his punishment. Higgins sought to have prison officials dismiss his case and return him to G2 status. The defendants moved for summary judgment, which the district court granted, finding that Higgins failed to show the required causation between the alleged retaliatory motive and the less favorable custody classification. On appeal, this court reversed, concluding Higgins had presented a genuine dispute of material fact as to causation and remanded for further proceedings. So he's already been through appeal once, right? The district court dismissed it and said, well, you haven't proved causation. And the appellate court said, well, no, he has enough to at least argue it, so, you can't dismiss for that reason. Following the remand, the district court permitted Higgins to amend his complaint, and he added a demand for monetary relief. Defendants again moved for summary judgment, arguing that Higgins' request for court to change his custody classification is moot because he's been in G2 custody since August of 2014. So, yeah, he's now in G2 custody at the time of this hearing. So it's moot, they argue. Reversal of Higgins' disciplinary case is barred by Heck versus Humphrey. Defendants are entitled to qualified immunity, and Higgins failed to prove the causation element of his retaliatory claims, which is really funny because that was the exact reason the appellate court reversed you in the first place. The district court again dismissed the case with prejudice, granting defendant's summary judgment motion because the record shows that Higgins' requested relief in his original complaint is moot, and that he's not entitled to compensation or punitive relief. On appeal, Higgins argues the district court did not address his request to have the disciplinary conviction reversed, and the district court erred in finding he was not entitled to monetary relief. Despite requesting and receiving an extension, the defendants, the prison officials, did not file an appellate brief, which, wow. I mean, that's just a way to show disrespect to the court, right? I mean, they've already been reversed once by the appellate court. And now, on retrial, right, the district court dismisses again for various reasons. And then the defendants over here don't even bother filing an appellate brief. That's going to leave a bad taste in the appellate court's mouth, man. They didn't even bother filing a brief, man. To state a valid claim for retaliation under 1983, a prisoner must allege a specific constitutional right, the defendant's intent to retaliate against the prisoner for the exercise of that right, a retaliatory adverse act, and causation. Higgins has a right under the First Amendment to file the grievance. And our court has already concluded that, as for the second, the intent element of the retaliatory claim, the statement suggests his own vote was motivated by retaliatory intent. It is undisputed that the increase from G4 to G5 is an adverse act. And our court has further concluded that Higgins has at least created a factual dispute about the retaliatory motive causing Jones to change her vote. Despite this, the district court grants summary judgment to defendants, dismissing the claims with prejudice. The court did so by focusing on specific forms of relief. So, the district court is trying to get rid of this thing. Because Higgins has been in G2 custody since August 2014, we find the claim requesting transfer to G2 custody is moot. Additionally, because the claim is moot, we deny Higgins' motions to supplement the record with additional classification committee records. Higgins' complaint also requested relief in the form of reversal of a disciplinary case. On this appeal, Higgins urges us to reverse his disciplinary case because it resulted in a 3-year delay in his parole consideration date. We decline to consider this argument because a court reviews for errors. We do not decide facts or make legal conclusions in the first instance, but review an action for a trial court for errors. Instead, we remand to consider this unresolved issue. So yeah, we're going to go back to the district court again. This will be try number 3 for the district court because, of course, originally it was filed and then appealed, now appealed again. And so maybe the third time, maybe the district court can review the issue as to whether or not this is, a problem. Higgins alleges that he's endured much harm and suffering, and he was housed in an extremely violent atmosphere where inmates were regularly gas-bombed for violent outbursts. However, the record does not show evidence Higgins experienced physical injury, and the relevant law requires that no civil rights action may be brought by a prisoner confined in jail, prison, or other correctional facility for mental or emotional injury suffered in custody without a showing of physical injury. In order to receive punitive damages, Higgins must show defendant's behavior was motivated by evil, intent, or involved reckless or careless indifference to their rights. So yes, some forms of relief are off the table because of the nature of relevant laws, right? He's already been transferred to G2, so we can't order that because it's already happened. He can't get compensation damages because under the relevant law, you can't get compensation damages unless there's physical injury. You can't get damages for merely mental injuries. There has to be physical injury under the relevant federal law. So we can't get compensation damages. But what remains available is punitive and nominal damages because they don't require that injury. So let's consider that. Higgins provided evidence that during the custody committee's voting, Navarrete said, "Let the record show that I'd rather put you in closed custody, G5, for all this trouble," referring to the fact that Higgins filed a grievance, and the case was overturned because Navarrete forgot to sign the paperwork. Responding to Navarrete's statement, Jones changed her vote from G4 to G5. The district court, citing no law, found these statements do not show an evil intent, but it show at most vindictive. So not evil, but vindictive. The Court of Appeals has a problem with this distinction. The Oxford English Dictionary defines vindictive as actions being characterized by a desire for or exercise of revenge. As evidence, desire of revenge may well qualify as an evil intent, and at least in the context of voting for harsher custody classification, it raises a genuine issue as to whether defendants acted with reckless or callous indifference to the First Amendment right to file a grievance. Because the record presents a material question of fact as to the intent underlying Navarrete and Jones's conduct, we revert the district court's grant of defendant's summary judgment motion and remand for further proceedings. Additionally, because Higgins requested any monetary damages the court or jury deems appropriate, the district court should also consider nominal damages on remand. Thus, that brings us to the end of the case of Lawrence Higgins versus Ernest Navarrete. But of course, not really the end of the case. Because for the third time, three times, the district court is going to have to try again. Yes, because, it turns out that there is a First Amendment right to go through the formal grievance process of a prison. And you can't do retaliation on that basis. And if you do the retaliation, you're bad. So, yeah, and it seems the district court keeps dismissing, even though there seems like there's some tribal issues here. And so the Court of Appeals basically just lays it out. Look, guys, you got to actually consider this. There seems to be some evidence of the whole vindictiveness thing. There seems to be some evidence of causation, in the alleged thing. And yeah, he could get nominal damages or punitive damages as potential relief. So, it might not be much, but it's something. So it's something. So yeah, district court, try again, at least for a moment. That brings us to the end of discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.